Good morning, good afternoon, good evening. I hope you're all doing well this fine Wednesday. We're talking Delphi today. And we got an Andrew Baldwin special that came out last night, my time. Andy Baldwin at his very best. 24 pages of Andy Baldwin. So we're going to read through it. I know I'm a little bit late to the party. This came out last night, my time, and I couldn't be bothered, honestly. I couldn't be bothered getting up and, doing this. I thought it'll save till tomorrow. But I know that some of you will have heard whoever else read it. I fell asleep listening to Criminality last night, reading this. And I've seen a little bit of Defence Diaries. I caught about 20 minutes of R&M as well yesterday. So, yeah, I'm a little bit late. However, I got some points. I got some points to raise, so we're going to go through it. This is an absolute circus. It would be completely laughable. That's all it's worth. It's just laughable. Except there's a man in prison for 130 years. I'm sure that Andy Baldwin has got better things to do with his time. But he probably sits down at his computer and his keyboard is hot with the pressure of him hitting those keys. He can just probably get one of these out pretty quickly. He knows exactly what he wants to say. And yeah, Andy Baldwin special. So we're going to do this. We've got plenty of time, actually. We've got 3 hours before the Karen Reid hearing, yet another hearing. So there's a hearing yesterday for Karen Reid. There's another one today. And at least, look, Judge Bev's annoying. If you're following the Karen Reid case, right, Judge Bev is annoying, but at least she lets them mudsling in public. She grants them a hearing so that they can get it all out. They can get it all off their chest. Hank Brennan can play the big man. I think he's got a bazinga. But Judge Gull, she'll deny this. She'll deny this without hearing. You can guarantee it. I'll eat every single hat in my house, and I've got quite a few. If Judge Gull grants them a hearing. Of course they should have a hearing on this. It's ridiculous. These titles of these motions, they're going to get longer and longer and longer because, McClellan might reply and then it'll be, let's have a look. It'll be State of Indiana's reply to Richard Allen's verified reply memorandum. It'll just go on and on and on. The titles will end up like half a page. It's stupid. Let them have a hearing. Let them get this all out. I mean, look, Nick McClelland, he's just got this, he's got this wall of protection, and that's how he's won. That's how he's won this case. This is why Richard Allen is in prison for 130 years. Oh, something else pissed me off as well this morning. Tanner Horner's trial has been delayed by another year. Can you believe that? Jury selections happened. And now Tanner Horner's judge, whose name I don't know, has granted the defence a year, an extra year to prepare. The trial was due to start on the 17th of this month. If it was televised, I was going to stream it. And I just happened to check this morning. Something, little bird just kind of came into my head, and I thought, I'll just check, whether this trial, is there any news on whether it's going to be televised or not. I'll just check, and then, I can tell you guys that I'm definitely going to be streaming it or not. But no, defence needed more time. So the trial doesn't start now until the spring of 2026. Who's Tanner Horner? He is the killer of 7-year-old Athena Strand. from Texas. Tanner Horner admitted it. And he didn't just give a confession, right? You know, didn't just confess for the sake of it. He actually told them where Athena's body was. They went to that location and hey presto, there was Athena's body. So he absolutely knew. So look, he's a FedEx driver. There's probably video evidence. Don't these things have dash cams? Don't they have a camera on board? So there's going to be evidence of everything. But no, after this confession, decides to plead not guilty. And because this is a capital case, they're going for the death penalty, then the judge is being ultra extra careful and has granted them a whole year of a continuance. Unbelievable. So I'm very pissed off. I was looking forward to a little bit of justice here. But no, we can't have that, can we? Can't have that. Yes, I'm aware. I'm aware. Yeah, Mullin. Back to this case. Steve Mullin has taken back over as chief of police. It seems to be that in this little part of Indiana, if you do a bad job, well, it doesn't matter. It doesn't matter. You don't get reprimanded. You don't get demoted. No. So after his little stint as an investigator in the prosecutor's office, Steve Mullin is back of the chief of police in Delphi. He was chief of police when they lost all of those interviews conveniently at the beginning of the Delphi case. But no. Okay. All right. But hello, everyone. If you're just coming in, you've not missed anything. I'm just ranting at the moment, but we are going to get right into it now. Okay. So it's 24 pages. It's not going to take us that long, I don't think, to get through, even though it's 24 pages, and I might have to stop and rant at every sentence. I'll try not to do that. I'll try not to rant after every sentence. It becomes easy to rant, but here we go. Richard Allen's verified reply memorandum to State of Indiana's response to preserve and produce and request for sanctions. So, in addition to being a response, this is a request for sanctions. Sanction Nick McClelland for all of the nonsense that he's doing. Can't see that happening. Not in a month of Sundays. Comes now, Richard Allen by counsel files this reply to the State of Indiana's February 28th, 2025 response to Allen's motion to preserve and produce, and also request sanctions for the state's violation of Carroll County local rules concerning exculpatory evidence. In support of said motion, Allen states the following. The prosecution's response brief provides proof that the State of Indiana failed to turn over exculpatory evidence to the defense. Well, it's not the first time, is it? It's not the first time that Nick McClelland's got away with this crap. In his response, the prosecutor glosses over the fact that he was in possession of letters that he failed to turn over to the defense before trial, even though in a February 13th, 2025 email, he denied possessing such letters. He'll get away with it. McClelland also has no explanation as to why a letter from Davis, this is Ricci Davis, the inmate, all of this is blown up over, from October 15th, 2024, is missing and cannot be found. Yeah, well, I think they've got it. And because it contains evidence that Nick McClelland doesn't want the defense to have, they've conveniently lost it. They should just re-employ Kathy Shank. She'll find it. It'll be in a box, in a desk drawer, or in a cupboard. It'll be in a little box that no one's looked at for 5 years. Right. Instead, the prosecution spends the majority of his response denigrating defence counsel. Yeah, well, Judge Gull's good at that, so Nick McClelland's just following her rule, isn't he? Following her lead. Prosecutor McClelland is not the arbiter of exculpatory evidence or whether he has an obligation to turn it over. Exactly. The law is the arbiter. Well, she chastised the defence, saying, oh no, denied without hearing because you haven't included any law. That was to a previous motion. But now we've got lots of law in this. So what will be her excuse this time? Not that she needs an excuse. You know, she just goes deny without hearing, doesn't include any, you know, factual basis, any law, any explanation. It's just denied without hearing. I'd like Judge Gull to take a leaf out of Judge Hippler's book here. If you were in my recent lives about Koberger, where I read through Judge Hippler's response, his orders, and you know, he laid it all out, why he denied Brian Koberger's motions, laid it all out, very detailed. But no, it's like two ends of a scale of competence. Exculpatory evidence is defined as evidence tending to establish a criminal defendant's innocence. Carroll County Local Rule 18b2 also requires McClelland to turn over exculpatory evidence. Based upon his February 28, 2025 filing, we now know that the state of Indiana had certain letters in its possession in October 2024. Yeah, he's had to admit it. He's been caught out yet again. He's had to admit it. He's turned over 2 letters. He's turned over the ones that he thinks, I don't know, prove his case that these letters weren't exculpatory. That's not the point. That's not the point. Nick McClelland doesn't get to decide. He needs to be turning over things in his possession. But it's like, do you remember that before trial? There was a motion that Nick McClelland filed that he had to take back. He had to delete because it gave him away that he'd been reading the defence's ex parte filings. That he knew stuff about Rick Allen that he shouldn't know. Well, it's kind of like that he's getting caught out. Dear me. All right, so he failed to turn them over until February 28th. The prosecution only produced those letters after the defence sought those letters, being forced to file a motion to produce those letters after the prosecution failed to admit being in possession of those letters. Yep. The behaviour of the state is consistent with a pattern of behaviour. No shit, Sherlock. This is no surprise to anybody. This is what they've been doing all along. There isn't a judge, a case anywhere that I've ever heard of who would put up with so much incompetence from the state or from either party. There isn't a case like it ever that I've ever seen. And probably never will see for a long time, I hope. Like I said, this would be absolutely laughable. Was there not a man in prison, most likely completely innocent, for 130 years? Okay. Pattern of behaviour that has greatly impacted the defence and Richard Allen's constitutional rights throughout the entirety of this case. And why Judge Gull hasn't been reprimanded is another mystery to me, as will be recounted later in this memorandum, because this is an Andy Baldwin special. A pattern of withholding exculpatory evidence may lead to a reversal and new trial. Not in this case, because Judge Gull. Pruitt versus Estate, 2004. This case illustrates what happens when the state engages in a pattern of withholding exculpatory and material evidence from a defendant prior to trial. In Pruitt, the Court of Appeals reversed the conviction when, soon after the conviction, the defence counsel learnt of evidence that the prosecutor failed to turn over to the defence prior to trial. Yeah. This entire conviction should be vacated. It should be, she's within her rights to do this. The judge is within her rights to do this, to vacate the conviction. We could let Richard Allen out on bond, give him a little nice ankle tag, like all shiny and new and everything, and then start again. Just start again, make them do the trial again. This time, allow the defence a proper defence, and let's see what the jury decides then. Defence theory. At Allen's trial, the defence indicated that the evidence supported that on February 13th, 2017, the victims were abducted, taken somewhere else, perhaps in a vehicle, and then during the early morning hours of February 14th, 2017, after the search parties had left the area, were ultimately transported to the location where they were found on February 14th. Further, the defence theory was that evidence strongly supported that multiple people were involved in the abduction and murder of the victims. The defence theories were detailed in the defence's opening statement and throughout the trial, or in offers to prove from August 1st, 2024. And if you've been following the case, you'll know that the defence theory focused around a group of Odinists. But the jury didn't hear any of that. They weren't allowed to hear any of that because of Nick McClelland's motion in limine. That was granted, and there was no nexus. When they tried to get this stuff in a pre-trial hearing, no nexus. When they asked again during the trial, no nexus, no connection between any of these people that you're not allowed to mention, including Ron Logan, Kegan Kline, as well as the Odinists, not allowed to mention even Ron Logan, not allowed, even though he was the FBI's chief suspect for a long time. Kegan Kline was a big, massive, fat person of interest for a long time, but no, defense not even allowed to bring those people up, not allowed to mention them. It would be contempt of court if they'd even mention their names. State's theory, which is a lot of bollocks. The state's theory was that in some order, the following events occurred. The killer, acting alone after running or briskly walking across the bridge. This is an Andy Baldwin special, this is Andy Baldwin's brilliant writing. It makes it come alive. Acting alone after running or briskly walking across the bridge to catch up to the girls, since he was not seen in the 207 photograph anywhere on the bridge, was seen on video walking casually and not panting like a 45-year-old man who had run across the bridge, then abducted the two victims, walked or slid down a steep hill with those victims. Then, in a panic, after observing a van, Brad Webber's van, that didn't even arrive at the right time that the state needed him to. No, we've got video evidence now, as did the state. The state had this in the discovery. This was video evidence that the van only passed by. It was seen on camera at 2:44, so it would only have passed by the bridge at 2:45. So that's a good 15 minutes later than it needed to arrive for this theory to even work. And this is not even mentioning that this theory does not work in relation to Libby's phone data. As I've talked about in many previous videos, it doesn't work. The state's own analysis of Libby's phone data refutes this theory. All right, so observed a van, corralled those victims across an active creek. I don't know what an active creek is versus an inactive creek. I suppose one with water in it. While holding a gun, and then both victims somehow were undressed, but the younger victim was later redressed in the pants, bra and sweatshirt of the older victim, and the lone panicked killer murdered one victim, then murdered the other victim without anybody hearing any screams, in spite of sound travelling very well throughout that area, all the way to the bridge. Not that far away. The bridge, you can see the bridge from the crime scene. Then the lone panicked killer moved the older victim from one area to another area next to a tree without any drag marks, no drag marks, indicating that he either carried her from one place to another. All that activity, according to the state's theory, occurred in a 19-minute time frame. I mean, it's unbelievable. All of that in 19 minutes. Okay. The killing, easy. Slitting people's throats ain't going to take very long. It's everything else. You know, it's the down the hill. It's the attempt to essay. It's the panicking. It's the walking them through the woods, across the creek, up the other side. Then deciding to kill them. And then this bizarre redressing. Because the redressing of Abby had to happen before 2:32, because the phone, which stopped moving at 2:32, was underneath Abby, who was dressed. So Abby, for Abby to be like there and placed there, all this is happening in a short space of time. So 19-minute time frame between 2:13 and 2:32, when the older victim's phone stopped moving, having been placed under a shoe under the younger victim's body. After the murders, the state's theory was that this panicked killer then took time to place sticks on top of the victims in particular patterns as depicted in photos admitted at trial, and then, in spite of his panic, in spite of it, hung around the crime scene for over an hour before exiting the crime scene northward near a cemetery, before this panic killer chose to walk westbound towards his vehicle on 300 North in a bloody outfit, knowing he would be in full view of any vehicles travelling that road. Yeah, it's all open. If you've ever seen anybody driving along 300 North in that area, it's all open. If you were a muddy and bloody man who just murdered two girls, bear in mind that people were at this point turning up to look for Abby and Libby. You wouldn't be walking along 300 North muddy and bloody, would you? No, but that's what the jury were asked to believe, and sadly that's what the jury did believe. Dear me. In full view of any vehicles, including anybody now starting to search for Abby and Libby. Unbelievable. The state's theory was not that multiple men and women were involved in the crimes, but one man alone committed all these acts and did so on the afternoon of February 13th, 2017. The jury were hoodwinked. They absolutely were. Ricci Davis letters provide exculpatory information that supports the defense theory and negates the state's theory. That's why these letters were hidden. Also provides other information that the defense could have utilized for trial or to support its request for third-party suspect evidence. Another reason why these were hidden, to be admitted into evidence. And it begs the question, what else does the state have that's also exculpatory that hasn't come out yet because the defense doesn't know about it? We don't know. We don't know what we don't know. In Davis's letters that the state of Indiana did not turn over to the defense before or during trial, Ricci Davis states that Kegan Kline, a key suspect in the case, confessed to the murders. Look, Kegan Kline's a big fat liar. I don't believe anything that Kegan Kline says. However, that's not the point. The point is that these letters should have been turned over to the defense to let them make an assessment about whether they were going to use them, how they were going to use them, were they going to investigate them, were they going to consider Kegan Kline in part of their third-party theory, were they going to present that to the jury? They didn't get the opportunity because they didn't know about these letters. A key suspect confessing to the murders is exculpatory evidence, as it tends to establish a criminal defendant's innocence. At a minimum, Carroll County local rule required McClelland to immediately turn over those evidence to the defence, even if he, McClelland, believed that the letters did not need to be turned over because of Davis's claim that Richard Allen was involved in the crimes alongside Klein and Logan. And look, Richard Allen is the man that's on trial, yet the state is choosing which information about Rick Allen is given to Rick Allen's defence. Like Nick McClelland saying, oh, well, you know, these letters don't exculpate Rick Allen, they inculpate him. Well, that's not your decision to make. They still need to be turned over, even if you don't plan to use them at trial. But Nick McClelland has now decided that he didn't need to turn them over because he wasn't going to use them at trial. Therefore, they're not part of the discovery, which is nonsense. Absolute, complete nonsense. All right. Carroll County Local Rule 18b2. Additionally, McClelland's claim that he was not obliged to turn over the letters because of Davis's claim that Rick Allen was involved is not a judgment call for McClelland to make. Richard Allen was at home on the evening of February 13th, 2017, and the morning of February 14th, 2017. According to Davis's letters, Klein indicated that Allen was with them during that night and morning assisting in the murders. It is McClelland's obligation to turn over exculpatory evidence to the defence and let the defence determine how to proceed. Absolutely. Richard is guilty, let it go, silliness. Why are you listening then? Seeger's mom. Why are you listening? If it's all silly, why are you listening? And if you're listening, why aren't you actually really listening? Is it because you've already got this, you know, tunnel vision? I would question your own ability to think, you know, even a little bit critically about this information rather than just having your little tunnel vision. If you can't think in any independent way, then piss off. You're not welcome here. I like people who think to listen to my live streams. If you're willing to think, then stick around. You might learn something. Okay, when police or prosecutors conceal significant exculpatory or impeaching material in the state's possession, it is ordinarily incumbent on the state to set the record straight. So the question is not whether the defendant would more likely than not have received a different verdict with the evidence, but rather, in its absence, he received a fair trial, understood as a verdict worthy of confidence. Okay, the jury in Richard Allen's case was out for nearly 4 days, a lengthy deliberation period. In this case, Kegan Klein's confession to the murders and also Klein's claim that Ron Logan was involved are clearly exculpatory statements. These were the two most likely suspects during the investigation. They were. FBI investigated him in 2017. Ricci Davis reported Ron Logan's confession to him in 2017. And seemingly, Nick McClelland protected him. Thank you, Sherry, for 10 Canadian dollars. That's very kind. Can't see how anybody thinks he had a fair trial. Never mind, he's guilty. I know. But then again, here we are. A jury convicted him. People are going to stick with that. If they're not willing to think about the actual evidence in the case and what the jury didn't hear, then that's what they're going to stick with. But thank you for the donation. It's very kind of you. And then Kegan Kline, well, his house was raided just 11 days after the murders because they found out via Libby's phone that he'd been communicating with her. House was raided. So both Logan and Kline were on the radar from day one. If it could be shown that they knew each other, it would be a significant fact for the court to consider when determining matters of the third-party suspect defence, and also for the jury to consider. Absolutely. The fact that Kline also implicated Alan would not have been a concern for the defence, as the defence knows that Alan has no linkage to either Kline or Logan. The reason the state wanted to withhold the letters, obviously. And also because the evidence supported that Alan was with his wife the night of February 13th and the morning of February 14th, when Kline is claiming Alan was with Logan and Kline committing the crimes. Had the defence known of the information contained in the Ricci Davis letters, it would have renewed its motion for a third-party suspect defence regarding Kline and Logan and would have further investigated these claims. Perhaps the defence would have sought a continuance to investigate the ties between Logan and Kline. The defence could have argued that Kegan Kline knew the details of the crime that no one else knew, and furthermore that he, Kline, was protecting an unknown third party by claiming that Alan was the third party after Alan's arrest. Only after Alan's arrest. The defence could do none of that, as well as any other number of legal, strategic, procedural manoeuvring, if it, the defence, was in the dark about the contents of the letters, while the prosecution was fully aware of that information. This thing alone is enough to overturn this conviction. But no, this is Judge Gull, everybody. The jury did have much evidence hidden from them. Absolutely they did. The details that Kline provided to Davis add to the exculpatory value of those letters. On page 4 of one of the letters, Davis claims that Kline detailed that the girls' bodies were moved 3 times and that they were not killed where they were found, and furthermore that their bodies were staged. There are facts consistent with the defence theory and facts that oppose the state's theory. Furthermore, in the letter, Davis claims that Kegan Kline details how the killers got nervous and left town in their own cars, with at least one of them going to Lafayette to get rid of evidence. It is known that Ron Logan went to Lafayette at some point in time, so later on in the afternoon, to purchase exotic fish after having a relative assist him, Ron Logan, in creating an alibi. We know all this, the cousin. We know that Ron Logan went to Lafayette, or at least someone did, to give him a till receipt that is time stamped at 5:21 that day. Thank you, Sherry, for the 5 gifted memberships. We've got Neat, we've got Spunky, we've got Keep Grinding Up, we've got Pete, Petominum, and Insanity Mum. Thank you for the gifted memberships, Sherry, and welcome you 5. If you've never been a member before, then check out the members area. We've got a bunch of stuff in there. These are all facts that Ricci Davis would not have known, but that the killer would know. All of these facts tend to establish Richard Allen's innocence. Whoa, Krista, thank you. $49.99. You are so kind. That is incredibly generous. Thank you very much. You're always so kind. In the second letter, Davis claims that back in 2018, he, Davis, reported that the victim's throats were sliced. It is something that only the killer would know, especially when the details of the murders were not known at the time. I don't know what Davis was talking about, where he was talking to, who he was talking to in 2018. I don't know whether that's a mistake that the state made or that Ricci made, that it was actually 2017, because it was May 2017 that his tip went to the FBI after Ron Logan had confessed to him about slitting the girls' throats. So I'm wondering whether that is a mistake and it's actually 2017. Catherine, you have no sound. Check your volume. Because we do have sound. Something only the killer would know, especially when the details of the murders were not known at the time. He also stated that he reported that the girls were hidden in a barn and also driven around at some point in time. This is consistent with the defense theory that the girls were driven in a car at some point and held somewhere until the search parties had left the area. And is inconsistent with the prosecution theory, who had everything all done and dusted and both dead by 2:32. On page 3 of that letter, Ricci recorded that Kegan Kline told him that the scene was staged, and furthermore mentioned that the girls could not be moved because the search parties were everywhere throughout the night at that time, meaning that the girls were moved to the place they were found only after the search party left the area. This is just as the defense claimed, thereby supporting the defense theory and negating the state's theory. Listen, everything negates the state's theory. The state's theory is nonsense. Everything negates it, even the state's own evidence negates the state's theory. In his February 12, 2025 interview at Newcastle Prison, so this would be with Andy Baldwin, Ricci Davis provided further details that he, Davis, claimed and believed that he also provided to the prosecution concerning details that Kegan Kline stated to Davis. In that interview, for example, Ricci Davis claimed that Kegan Kline stated that the girls were handcuffed to each other. After the meeting, defense counsel Auger Baldwin and investigator Matt Hoffman viewed the crime scene and autopsy photos to determine whether there was any indicators on the victim's wrists that would support this new information, that the victims were handcuffed to one another. The admittedly non-expert eyeballs non-expert eyeballs. Look, you've got to love Andy Baldwin. The non-expert eyeballs of the attorneys and investigator observed straight lines on the left hand of the wrists of both girls, which, if true, could indicate that one victim walked immediately behind the other, with each of their left hands handcuffed to each other so that they could not easily run away. Okay. It wouldn't be easy to run away, would it? Like, if you both had your left hand, or like the same hand, like if you're handcuffed somebody's right hand to the other person's left hand, then they can both run easily, can't they? Just run together. But the same hand on both victims, they'd have to walk one behind the other. That would be very difficult to run. That's interesting. That is interesting. If the defense had received those letters, it could have learnt these facts from Davis during a deposition if they weren't contained in the letters, and then had experts view same photos to determine whether the photos were indicative of the girls being handcuffed. Thank you, Sherry, for another 10 Canadian dollars. Thank you so much. Did you listen to Ricci Davis live jail call on Case by Case? He sounded so genuine. I did. I absolutely did. Yeah, it was really interesting. Well, thank you, Sherry. You're very, 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 very kind. Where were we? Okay, we've done that. Had the defense known of the Kegan Kline statements to Ricci Davis, it could have brought both Kegan Kline and Ricci Davis in for depositions after hours or during the weekend while the trial was occurring. Absolutely what the state didn't want. These depositions could have revealed additional information, including whether at some point in time Kegan Kline finally admitted that Richard Allen had nothing to do with the crimes, as Ricci Davis stated to counsel during a jail interview on February 12, 2025. He said at the time, like last October, he didn't want to help the defence. Like last year, he didn't want to help the defence because he believed what Kegan Kline had said, that Rick Allen was the third person involved. So it was Logan, Kline, and Allen. But then he realised that Rick Allen had nothing to do with it. So we've now got this, a free space. Who's the third man? Well, we know that Elvis Fields confessed. So does Elvis Fields have something to do with this? There needs to be a thorough investigation on whether Elvis Fields knew Ron Logan, and whether there is a connection with the Klines in some way, shape, or form. That maybe only half of what Kegan's saying is a lie, rather than all of it. Maybe there's some truth in there, and Kegan's just making up the rest. We don't know because it's not being investigated. And that's the problem. And Nick McClellan knows full well. This is just shady shit that he had to do to get the conviction. Because an even playing field where the scales of justice were held in equilibrium as they should be, there's no way that a jury could have convicted Richard Allen. No way. There'd be way too much reasonable doubt. Dear me. All right, and also to show that Kegan Kline's claim about the activities of the third person involved with him, Kline and Logan, was inconsistent with Richard Allen's whereabouts the night of February 13th and the morning of February 14th. The defence likely would have called up Kathy Allen to show that Richard Allen was at home during the time frame and not with Logan and Kegan Kline. Additionally, the defence could have asked the Department of Corrections to provide video from the very pod where Ricci Davis and Kegan Kline were housed to determine whether Kline and Davis were frequently talking with each other. Yeah, these places are cameraed to the hilt. They'll absolutely be able to know whether Kline and Davis were talking, at each other's doors, as has been stated. As Kline has apparently stated in States Exhibit 4 that Kline had only talked with Davis maybe 2 times. This is now what he's telling, like the murder sheet and other people that are texting him. He's saying, "Oh yeah, Ricci Davis is just a nonsense spreader. I've only talked to him maybe twice, and oh yeah, well, all right, we've got cameras in prisons." If the video shows that Davis and Kline talked to each other well beyond 2 times, then it would be determined that Kline was lying. Whereas, if the video shows that Davis only talked to Kline 2 times, it would show that Davis was lying. Yeah. Either way, the defence had a right to those letters to conduct its own investigation concerning the veracity of the contents of those letters. And this is something McClellan could have done. Like McClellan in the state's filing accused the defence of not doing an investigation into whether Ricci was telling the truth or not. Well, Nick McClellan's done exactly the same thing by not contacting the Department of Corrections and supporting the claim that Kline had only spoken to Davis maybe a couple of times. Well, that could be absolutely proven with video evidence. Just needs someone to go through the CCTV to see how many times approximately. I have to count every single time. Was it more than 2 or was it 2? I mean, it's not difficult to determine. It's just, you can fast forward through all the CCTV and say, right, there's 1, there's 2, there's our 2. Okay, is there more? McClellan could have done that. before accusing Ricci Davis and by connection the defence of lying and being, just dishonourable. What's good for the goose is good for the gander, Nick. You heard that saying? Anyhow, either way, the defence had the right to those letters to conduct its own investigation concerning the veracity of the contents of those letters. McClelland's claim that he did not turn over the Davis letters because he, McClelland, made his own determination that the letters were not in fact exculpatory, denied Allen and his attorneys the opportunity to conduct its own investigation from the information contained in those letters and to determine what to do, if anything, concerning the contents of those letters. Yeah, it's not his decision to make. In his February 28, 2025 response, McClelland makes much noise about Attorney Baldwin attempting to put into the public domain information through the filing before verifying that information. Well, it's exactly what Nick McClelland's done. It should be noted that Attorney Baldwin first attempted to work the matter out with McClelland via email before filing his motion. On February 12, 2025, Baldwin had emailed McClelland asking for the Ricci Davis letters. On February 13, 2025, at 2:41 p.m., McClelland responded as follows. The information that we have concerning Ricci Davis was forwarded to you as part of discovery. You had every opportunity to call Mr. Davis at trial or at the hearing on the third-party motive. You chose not to. Your strategy was not to call these people. How could they call these people? How could they call these people? How could they call these people? The third-party defence was banned due to lack of nexus. The trial is now over. Richard Allen was convicted. If you feel you need to file additional motions, then file them. The state will respond appropriately. The state will follow any orders the court puts out with regards to those motions. Yeah, because Nick knows that it will be in his favour denied without hearing. Before filing any motions, Attorney Baldwin made one more attempt to simply obtain the letters. The defence responded at 3:54 p.m. on February 13th. Ironic date, isn't it? Ironic date. By asking McClelland whether he was admitting or denying that he, McClelland, had received letters from Ricci Davis in the months leading up to the 2024 trial. McClelland could have quickly answered the question and then provided the letters to the defence and perhaps avoided any more filings. McClelland could have asked Baldwin to hold off on filing anything while he, McClelland, gathered the letters to turn them over to the defence. Instead, McClelland chose to ignore the defence's request, prompting the defence to file its February 14th motion to preserve and produce the Ricci Davis letters. Yeah, just ignore it. Just ignore it. It's going to go away. Yeah, it's going to go away. You don't need to do anything. It'll just go away. Because Auntie Franny will make it go away. She'll make it go away. Yeah, makes your blood boil. Yeah, mine too. Mine too. It should be noted that the defence was seemingly up against a deadline of sorts. If the defence waited to file their motion, the judge might rule on the motion to correct errors beforehand, which arguably will prevent the defence the ability to file the motion to preserve and produce, as such a ruling would arguably kick the case to the appellant lawyers. Well, yeah, she's denied everything anyway. She's denied everything anyway. So I think this is, unless she has a change of heart, unless she sees the light very quickly here, this is going to the Court of Appeals. Also note that in his February 13th email response, McClelland claimed to have provided the defence all the Ricci Davis letters during discovery. This was simply untrue and misleading. misleading statement typed on his computer and sent to the defence by McClelland. I love the way he writes. You can see, he really paints the picture. He should write novels. Like when he retires from lawyering, he should write novels. He's got that kind of style, hasn't he? Through his February 28, 2025 filing, this court learned that McClelland actually was in possession of these letters on February 13th, which contradicted McClelland's representation to the defence that everything had been turned over. He doesn't even care that he's lying. He doesn't care that he's lying, because Auntie Franny, she doesn't care either. She'll just deny without hearing. She'll probably try to disqualify the defence. Even though they're not formally Ricci Davis attorneys anymore, are they? And she doesn't even copy Baldwin, even though he's writing these filings. She doesn't even copy him in to her orders. I'm assuming that either Mark or Stacey is forwarding them on to him, because she's not even including him in the responses. Dear me. McClelland chose to intentionally mislead defence counsel about his, McClelland's, possession of those letters. McClelland was getting called out by the defence once again, and once again he was ultimately forced to turn over the letters, perhaps out of fear that the defence would eventually gather Department of Corrections records that would then expose McClelland's misrepresentation. McClelland's misrepresentation has yet to be explained by McClelland to this court or anyone else. So 2, once again, is referring to the other times that McClelland was forced to turn over items after being called out by the defence, as detailed in the next section of this memo. Oh, there's been so many times. So many times. 3, Allen and the defence is not conceding that the Department of Corrections records that McClelland admitted as exhibits are proof positive that other letters don't exist. The defence has no idea how records are kept or how accurate those records might be. The defence also is not sure how McClelland so quickly able to access those records from Newcastle. Exactly. How could he just click his fingers and Newcastle provides him with all of these records? Do you not have to file a request or something, or what? Certainly, as detailed above, McClelland's response to the motion to correct errors, in which McClelland provides details found nowhere in the Ricci Davis letters, provides a compelling argument for the belief that either other letters exist or video exists that has not been turned over. Yeah, McClelland has already said that Ron Logan confessed that he took Libby's phone battery out. Well, that's not included in the 2 letters that Nick McClelland provided in his last filing. So where's Nick McClelland got that information from? It's either from an interview with somebody that the defence doesn't have, or it's in one of the letters that Nick McClelland has read but hasn't turned over to the defence. So yet again, he's giving himself away. Are the letters McClelland finally provided to the defence truly the only letters and or videos in his possession? McClelland's recent response to the defence motion to correct error provides troubling statements that cast doubt on McClelland's claim that these are the only letters or evidence that are in the prosecutor's possession. In the prosecution's response to the defence motion to correct errors, in an apparent attempt to discredit Ricci Davis, McClelland claims that McClelland, had information that Ricci Davis had claimed that Ron Logan, there we go, took batteries out of Libby's phone. It's curious. because the prosecution has failed to produce any document or videotape in which Ricci Davis makes such a claim. Not in the letters, and they only had 2 letters, they say, and he says there's no video interview of Ricci Davis. No video interview. How do you take the battery out of an iPhone? You need a little screwdriver. It is possible. It's fiddly. I can't see Ron Logan doing it. I mean, you'd be able to tell, like, if Libby's phone, like, it would have been shown that, you know, it wouldn't be placed under Abby, would it? Like, in its case, if the battery had been taken out. So I think that's untrue. Not saying that what Ricci has said is untrue, but what he's been told is untrue. Unless there's another phone. Like, if there was another phone that, you know, was one of the older phones that you could just, you know, click the back off and take the battery out. There you go, unless you're referencing burner phones, we don't know. Exactly. You know, it may not have been Libby's phone. It may be batteries out of the burner phones that they were using. And Ricci's just misremembered and just kind of put Libby's phone in when actually it's not. It's the phones that they were using, the killers were using. And they took the batteries out and disposed of them. Or maybe somebody did take the battery out of Libby's phone and then put it back in again. I doubt it, though. I doubt it. Okay. So curious because the prosecution failed to produce any document, videotape in which Ricci Davis makes such a claim. The defence has found nothing. This leads to serious questions of where McClellan learned this information. The defence is left with one of 2 possibilities. 1, McClellan has additional Ricci Davis letters, reports or video from where he, McClellan, gained that information. Or 2, for reasons that are unknown, McClellan made up the story. Yeah, he just lied. He just made it up, which I wouldn't put it past him. But I think it's more likely that he's read it or heard it somewhere in content that he hasn't turned over to the defence. And he knows full well that there is more information that he hasn't turned over. It seems unlikely that such a specific story would be made up, leaving the defence to conclude that McClellan had additional Ricci Davis letters, reports or video that has not turned over to the defence. Yeah, it's an obvious conclusion. He's guffed up again, like he did when he made that motion and talked about Rick Allen in a way that he shouldn't have known about because it was from an ex parte filing. Dear me. McClellan does not explain to this court nor anyone else from where McClellan claims he learnt this information about the batteries, nor did McClellan back up his story about the batteries with an exhibit attached to the filing. Yeah, accuses the defence when they don't back their stuff up, but he just makes random stuff up and then puts it in, and then he gives himself away. He's not that good at this. You know, he's an absolute gaslighter, but he's not that good at it. Also, note, in that email, McClellan requested Attorney Baldwin to file something, which Baldwin did, only to have McClellan then cast aspersions about the filing. Yeah. McClellan's history of holding on to exculpatory evidence until being forced or called out by the defence. Unfortunately, it has been the historical pattern of the prosecution like I've never, ever seen before. McClellan made the decision to hold on to those letters until called out by the defence, much like he made the decision to hold on to other exculpatory evidence over the course of this case. Again, Indiana Courts of Appeal have commented on patterns of withholding exculpatory evidence and have even reversed convictions when prosecutors have exhibited such patterns, i.e. Pruitt. 1. Steve Mullin, the Delphi chief of police at the time of the murders and current Delphi chief of police. His claim that the Brad Holder and Patrick Westfall and other crucial early interviews between 2/14/17 and 2/20/17 were recorded over or not relayed to the defence, or was not relayed to the defence until 1/30/24, in spite of the defence asking for the evidence since August the 10th, 2023. They finally had to admit they didn't have all of those interviews. Why? Oh, there was a problem with the DVR and they'd all been recorded over. Oh, okay. Yeah, that was Mullin. But the prosecution, they didn't admit it until they were forced, their hand was forced. As anyone in the criminal justice system knows, often the most important interviews are those interviews closest in the time to the crime. Absolutely. Brad Holder and Patrick Westfall were on law enforcement's radar screen as suspects very early on in the case. A fact that is evident from reviewing emails all the way up the chain to Doug Carter in the early days of the investigation. Those emails were admitted as evidence during the July 30th, August the 1st, 2024 hearings. Because of law enforcement's very early interest in Brad Holder and Patrick Westfall, each were quickly found and then quickly interviewed on February 17th, 2017, within 3 days of the murders. On August 10th, 2023, the defence first unveiled to the prosecution that the defence believed that the state's own evidence supported that Holder and Westfall were involved in the murders. From a single 2-page document found amongst hundreds of thousands of documents, the defence found evidence that law enforcement had interviewed Holder and Westfall on February 17th, 2017. I think Westfall was interviewed on February 19th, if I remember rightly. So Holder was February 17th and Westfall February 19th, I think. And that both interviews were memorialized through audio video tape. It was after the August 10th, 2023 deposition of Jerry Holman that the defense began demanding those interviews, which the prosecution should have already provided to the defense. When McClelland and Mullin failed to turn over those interviews or explain what happened to those interviews, the defense called out the prosecution in the Franks memo filed September 18th, 2023. Footnote 66 on page 56 of the memorandum details that the prosecution had failed to turn over the Holder and Westfall interviews that the defence had been seeking. Daughter of Scotland, my eldest member for 43 months. That's amazing. Thank you so much. You're my oldest member. I'm sure you must be. Okay. Even after the Franks memo was filed and the defence alerted the court, calling out the prosecution for not turning over the Holder and Westfall interviews, the prosecution still refused to answer the very simple question posed by the defence of where is the Holder and Westfall videos? Please turn them over. The defence heard crickets. Instead of immediately alerting the defence on August 10th, 2023, that those videos had been taped over, McClelland and Mullin said nothing. Finally, on January 30th, 2024, the prosecution provided a document that detailed some of the contents on certain hard drives it had turned over to the defence. In the fine print on page 5 of this document, the defence finally learned what McClelland and Mullin were claiming happened to those crucial interviews. They were recorded over. Angie Baby, member for 19 months. You're well on your way to an OG badge. Not long now. Not long. They were recorded over, along with all other crucial interviews between 2/14/17 and 2/20/17. Neither McClelland nor Mullin called the defence and said, "We should have told you this when you first got on the case, or at least back in August 2023. But those interviews you have been seeking for the last 5 months were taped over in 2017. I'm really sorry. It was a fuck up. It was our mess. I'm really sorry." But no. Defence counsel has practiced for over 30 years. During that time, if the prosecution in any other county ever received exculpatory evidence or learnt that certain evidence had been destroyed, it would have immediately contacted the defence to tell them on the phone or in person that the evidence had been destroyed. Yeah, you'd admit it. You'd fess up. In your earliest convenience, you'd fess up. You know you're going to get caught out. But no. Journey takes a trip, member, for 21 months. Is your OG badge in the post yet? Nearly. Only another 3 months to go. Only another 3 months. In this case, the defence was lucky to even notice Mullin and McClelland's claim that the crucial video was taped over, as such information was sandwiched between other minutiae contained in the document. Oh, that's saucy. Minutiae. As if like, oh, none of this is really important. You're just padding it all out with all these little claims, and then, oh, you just sandwich this big thing in. Just trying to brush it under the rug. You know you got to say it, but you're going to brush it under the rug with some minutiae. Big dose of minutiae, and then your big thing. Yeah. Typical gaslighter tactic. He's just not that good at this, is he? Christina, member for 29 months. Don't think Abby and Libby have justice yet. And really sadly, no, they don't. No, they don't. It's criminal what's happened in this case. Absolutely criminal. I mean, double murder of 2 little girls is horrific, but the way that this case has been treated since day one, and no one has been accountable for all the complete mess-ups. There's been so many. And Rick Allen is the fall guy for all of it, seemingly. This should also not be overlooked. If, in fact, those crucial videotaped interviews were actually taped over, it would be colossal news that Mullin and McClelland would not have forgotten. Absolutely. Of course they would have known. Losing such evidence would be the talk of the unified command due to the serious nature and potential serious consequences of losing such important evidence. To lose such crucial evidence early on in the case would not be the type of thing that would ever leave the memory of the man in charge of that evidence, Steve Mullin, the then and current Delphi Chief of Police, nor the minds of those in unified command. Therefore, when the defence requested the prosecution to turn over those interviews, Mullin and McClelland should have immediately said to themselves, "Oh no, those interviews were erased back in 2017. I need to immediately tell the defence. I should have told them that when they got on the case, but I will do it now. Thank you for the reminder." It's inexplicable that Mullin and McClelland would not have remembered in August 2023, when the defence first requested those interviews, that those interviews had purportedly been recorded over. Yet, neither McClelland nor Mullin told the defence of the earth-shattering type of news that Mullin had known for 6 years at that time. Has there been any consequences for such a colossal effed up situation? No. Was he disciplined? No. Was he fired? No. Was he re-given the same job? Yes. Yes. After his stint as chief investigator of the prosecutor's office, he's now back to chief of police of Delphi. That's Indiana's finest for you, that is. Okay. To make matters worse for Mullin and McClelland, when the defence finally learnt of the so-called recorded over interviews, the defence asked if there was some documentation memorialising what exactly happened to those interviews, how it had happened, that crucial evidence had been recorded over. So surely a report existed that would explain this terrible accident that caused crucial evidence to be forever lost. However, no such report had yet to be tendered to the defence. Some point in time later, the defence finally received such a report. It was drafted by Steve Mullin. Inexplicably, it was undated. Yeah, because he had to rush something in. Yeah, not something that was already there to explain it. No. Therefore, no one knows if the report was drafted in 2017 or sometime in 2024 or anywhere in between. That document was entered as an exhibit at the March 18th, 2024 motion to dismiss. This undated document is not normal, nor the normal way that law enforcement and prosecution operates. Well, it is in this case, because there's no consequences. There's no being held accountable. And that, my friends, is the fault of Judge Gull. Is it all done on purpose? Yes. Yes. The question must be asked, therefore, why did Mullin and McClelland not immediately alert the defence that the Holder and Westfall and many other interviews were recorded over when the defence first asked McClelland and Mullin for those interviews in August 2023? And why did Mullin and McClelland not turn over the undated documents purportedly explaining how the interviews were recorded over until after the defence requested the document? The defence has not seen anything other than an undated document and the words of McClelland and Mullin that support that the interviews were actually recorded over. This is not normal and it's very troubling. And that is stating the absolute honest truth there. It's obvious how troubling this is. And people are just willing to say, well, Richard Allen's guilty, it doesn't matter. Richard Allen's guilty, none of this matters. That's not how justice system operates. I'm sorry. You're just absolutely deluded if you think that this is okay. You're deluded. Neither McClelland nor Mullin, nor anyone else in Unified Command, has ever explained to this court, nor anyone else, why they did not immediately alert the defence that crucial evidence sought by the defence had been purportedly recorded over. Neither McClelland nor Mullin or anyone else had ever explained to this court, nor anyone else, why it took 5 months before providing a document detailing the claim of Mullin of what happened to those interviews. There are 5 valuable months during which Richard Allen's counsel could have been investigating the actual claim that those interviews were recorded over. This is not normal. 2, for 4 months, McClelland held on to exculpatory evidence he had in his possession from Todd Click's lawyer, including a certified letter detailing how a law enforcement officer was concerned, essentially, that McClelland may have the wrong man charged based upon evidence that he, Click, and 2 other law enforcement officers had gathered over a lengthy investigation that led them to believe that Holder and Fields and perhaps others were involved in the murders. As this court knows from the Franks memo, but the court doesn't know because she never read it. I'm pretty confident that Frangel denied it without hearing and never read it. Quite confident. Including documentation provided to the court in that memo. On May 1st, 2023, McClelland received through the United States Postal Service a certified mailing from attorney Paul Barada, that detailed why his client, Todd Click, was concerned that McClelland did not have all the information necessary before making an arrest. This certified mailing not only contained a letter, but also the actual evidence that Click and law enforcement officers Kevin Murphy and Greg Ferenczi had gathered during their investigation. This included several videos that the prosecution had never turned over to defense from the likes of Elvis Fields, Rod Abrams, Ned Smith, and Johnny Messer. Again, in a normal world, this would have been an earth-shattering mailing to receive if you are a prosecutor. Normally, this mailing will cause a normal prosecutor to immediately contact the defense lawyers by phone to alert them that the prosecutor had received this information that clearly was exculpatory. However, that did not happen. Instead, the prosecutor held on to the contents of that certified mailing for over 4 months. The prosecutor only turned those documents over to the defense after it became clear that they, the defense, would soon be learning of that certified mailing. In the August 10th, 2023 deposition of Jerry Holman, the defense provided Holman and the prosecution with the 12-page Odin report, where the prosecution had to know that Click was a member of that investigative trio of law enforcement, along with Kevin Murphy and Greg Ferenczi. McClelland had to have understood that it was only a matter of time before the defense would learn from Click himself that he, Click, thought his lawyer had mailed a letter, much like Ricci Davis, to the prosecutor with exculpatory evidence. So that time, a lawyer, not an inmate, not as easy to, brush under the carpet and accuse of lying. McClelland's failure to immediately turn over this exculpatory evidence has never been explained to this court or anyone else. Not that the court would care, but there you go. Why did it take McClelland over 4 months to turn over this evidence? Similarly, it took McClelland approximately 4 months to turn over the Ricci Davis letters. Delayed discovery of exculpatory evidence without explanation is not normal, but has been a consistent pattern in this case. Indeed it has. 3. Why, in a September 6, 2023 email to the defense, did McClelland claim that the Purdue professor, the Purdue professor, this was pathetic. This was absolutely pathetic what Nick McClelland did about the Purdue professor. This is crazy. Crazy. Okay, Purdue professor. So McClelland claimed that the Purdue professor's identity was unknown and perhaps would never be known, when in fact law enforcement had known the identity of the Purdue professor since mid-August 2023, if not before. Of course they knew who they were. They don't ask professors to write reports and then just immediately forget who they are. That's crazy. Why did the defense only learn of the Purdue professor's identity after the Franks memo was filed, calling out the prosecution for absurdly claiming that it may not be able to learn his identity? There can't be that many Purdue professors who study things like runes and Odinism and stuff like that. Can't be that many to choose from. I think if you rang Purdue University, they might be to direct you to at least the right department. Dear God. In yet another example of what appears to be an attempt to conceal exculpatory evidence, McClelland has yet to explain to this court, not that the court cares, or anyone else, why he sent an email to the defense on September 6, 2023, claiming that he and law enforcement did not yet know the identity of the Purdue professor, and more curiously, that they may never learn of the Purdue professor's identity. The Franks memo was filed on September 18th, 2023. Coincidentally, the very next day, lo and behold, Jerry Holman actually found the very next day, Jerry Holman, he had this light bulb moment. He's like, I know the Purdue professor. I know who he is. Actually found him and interviewed the missing Purdue professor, Jeffrey Turco. Only 13 days earlier, it was thought that his identity may never be known, according to McClelland. But after the Franks memo, where the missing professor was discussed, he was found almost immediately. They're not good at gaslighting. They're not good at this stuff. I don't know why they're allowed to continue to do it. They're just not good at it. Dear God. Let there be no doubt, the Purdy professor's report, and even his October 19th, 2023 interview, revealed the murderers may have left behind sticks in the form of runes, consistent with the defense theory. This is called exculpatory evidence. While Turco admitted in his report from 2017 that he could not confirm what the sticks represented, he also said the argument that these markings constitute an inscription inspired by Norse runes or a modern recreation thereof is quite plausible. These words from Turco were not buried deep in the report, but were rather in the very first paragraph. It would not be surprising, I assume, if Holman or McClelland would want the defence not to have access to the report, as that report supports the defence theory that Norse paganists left the sticks behind in the form of runes. In his September 19th, 2023 interview with Holman, Turco commented, "I think the idea that somebody is trying to kind of replicate, early Germanic, runic script, that seems, I think, a given. A given that someone's trying to recreate, probably not doing it well, but it's a given that this is meaningful to somebody. These sticks are symbolic. There's a message there. Even if it's like a 5-year-old trying to write, it's a message of some kind." Both the report and Turco's own words in his interview stray far from what Holman represented in his August 10th, 2023 deposition as to what the Purdy professor's words were. Holman claimed under oath, being under oath doesn't matter to these people, that the Purdy professor had stated that the sticks were not Odinism of any type of cult worshipping or any type of a group that would have conducted the crime. Holman, simply put, misrepresented under oath the findings of the Purdy professor, who never said that the sticks were not representative of Odinism. Rather, the words the Purdy professor used were that the possibility was quite plausible and that it was a given. Holman's misrepresentation under oath is very troubling, and he has never explained himself to this court, doesn't need to, or anyone else. Doesn't need to, because Franny Gull ain't interested. The defence believes that evidence supports that McClelland did not want the defence to learn the name of the Purdy professor, and thus at September 6, 2023 email that he, McClelland, has yet to explain. Turco's report and interview supported the defence theory that Odinists, Norse paganists, were the murderers that left behind runes at the crime scene. After Holman's September 19th, 2023 interview of Turco, Holman prepared a report dated, because reports are normally dated, September 22, 2023, in which Holman admitted that he had known the likely identity, of the Purdy professor since mid-August 2023. If this is the case, again, why did McClelland not disclose this information to the defence instead of claiming to the defence on September 6, 2023 that the identity was unknown and may never be known? Because he's a pathetic gaslighter who's not very good at this. Again, McClelland has never answered that question to this court or anyone else. To the defence, it appears that yet another example of McClelland's attempt to conceal exculpatory evidence from the defence, much like the Ricci Davis letters, and this is not normal. Michelle, make a bulletin board like Castle. I have no idea what that means. Michelle, make a bulletin board like Castle. I have no idea what you mean, Tina. Yeah, Jerry Holman is not corrupt and he's not a liar. Absolutely. Absolutely. All right, number 4. There's so many of these. Why did McClellan fail to turn over the faked crime scene photo found on Holder's Facebook page, even to this day? And why did Trooper Roland Purdy twice swear under oath that the faked crime scene image was found on Brad Holder's Facebook before the murders, only to then change his story on August 1st, 2024, at the hearing on third-party suspect evidence? Ooh. Castle was a mystery series. Okay. I still don't know what you're talking about. All right. As has been noted in the Franks memo and at various other stages, the defence found among the massive amount of evidence a report from Trooper Ryan Winters detailing evidence that suspect Brad Holder had an image on his social media pages that depicted 2 girls mimicking the very crime scene that law enforcement found on February 14th, 2017. This image depicted 2 young girls lying on the forest floor with sticks, stroke branches on them, with one of the girls' arms posed almost identical to that of Libby German. This bizarre image had existed on Brad Holder's Facebook page before the murders, according to Trooper Roland Purdy. Why would Brad Holder, an early suspect, have such an eerie, similar image on his Facebook page? Unfortunately, the prosecution failed to produce that exculpatory piece of evidence. The defense had to drive to Georgia to obtain that image from the very man, Ryan Boucher maybe, who had located the image on Brad Holder's social media pages. Trooper Purdy then, under oath at his deposition in the fall of 2023, confirmed that the image was in fact on Brad Holder's Facebook page, but that he, Purdy, did not find the image compelling because it had been on Holder's Facebook page for a few years. On July 30th, 2024, Purdy once again confirmed under oath that this eerily similar faked crime image was found on Brad Holder's Facebook page. Then, very curiously, just 2 days later, Trooper Purdy recanted his 2 previously sworn statements, now claiming that he could not confirm that the image was on Brad Holder's Facebook page at all. Okay. Well, it was. Right. It was. Do you want to see it? If I can find it. I've shown it on previous live streams. I'm sure I can find it again. If you ask me nicely. There it is. All right, hold on. To me, that girl there, that's the way Abby was posed. That's exactly the way Abby was posed. Like with one leg straight, one leg bent, and then the arms like twisted around. It is weird. Like the sticks are not in the same places. But it's that one for me. That's exactly the position Abby was in. Exactly the position Abby was in. Libby's head was facing the other way, and her arm was kind of raised up more, and then her leg was flat. So Abby was like on her back. Abby was on her back with one leg straight and one leg bent, exactly like this, with her arms like bent round, exactly like that. And then Libby had her head facing this way with one arm up, like touching a tree, and then her legs flat. But that, to me, that is bizarre. That how close that is to Abby is absolutely bizarre. What's this photo? This photo was on Brad Holder's Facebook page. This is Brad Holder's Facebook page. So it's fake. This is not actual murdered people. Some would call it art, I guess. You know, some kind of like, I don't know, dramatic, meaningful thing to somebody. But what is bizarre is that it's in the woods. This girl here is in exactly the same position that Abby was in when she was found, and the sticks over the top of them. So you tell me. It's creepy how similar it is. And, you know, it's fantasy. Maybe it's fantasy at the time. And finally, perhaps, he got to live a fantasy in real life. I don't know. Oh, yeah, the Hanging Man painting. Yeah. Let's show that as well. This was Brad Holder's own. Hold on, let me find it. Brad Holder painted this himself. Let me find it. It's going to be right at the bottom, I can guarantee. Please hold. That? No, that's not it. I found the other one dead quick, so it stands to reason that I'm not going to be able to find this one. Definitely got it though. I've got an entire file on Odinism stuff, but it's just not organised in any way, shape or form. Not that any of my files are organised, because they're not. I struggle to find everything. I save it thinking, oh, that'll come in useful. And sometimes it does, sometimes it doesn't. But then I end up with a load of stuff in there that that means I can't find the stuff I want. Oh, come on now. Told you'd be right at the bottom. There's got to be an easy way to do this. Oh, why is it not there? I've definitely got it. There it is. There it is. There it is. There it is. All right. This That's Brad Holder's own work. Or at least he signed it. At least he signed it. So where's the hanging man with his leg? Interesting. Like a 7-year-old bed today. Yeah. It's just intriguing, isn't it? It's intriguing. All right, let's finish this document. Okay. Additionally, Trooper Winters claimed in his deposition that Indiana State Police could not locate the faked crime scene image that at one time was in possession of the ISP post in Lafayette. To this day, the prosecution has failed to turn over said image. This is not normal. It's also not normal for a seasoned state trooper like Roland Purdy to retract 2 prior sworn statements during a hearing in which the mimic crime scene image was a central piece of the defence's argument to allow third-party suspect evidence at trial. 5. Video of Brad Holder and Westfall in pagan ritual in Fort Wayne. The defense was fortunate enough to locate amongst hundreds of thousands of documents a 2-page email from Greg Ferenczi to Tony Liggett dated December 12th, 2018, in which Ferenczi described a strange video that Brad Holder took of a pagan ritual in Fort Wayne, Indiana. In the video, Brad Holder was tape recording various people at a ceremony, periodically yelling out things like, "Hail Thor!" At the end of the video, Brad Holder tape recorded Patrick Westfall standing next to a tree and using his hand to seemingly mark something on the tree. Well, what he said, I've seen this. It was on Brad Holder's Facebook. I've actually watched this. I don't think I screen recorded it, though. Maybe I should have done, but I didn't. But it definitely was on Brad Holder's Facebook. Whether it still is, I don't know. Patrick Westfall, like, he's a tall guy, and he was like reaching up, and he told Sleuth Intuition that he was putting a coin into like a crevice in the tree. It's like an offering to nature, to the gods, not painting something on the tree. But whichever it is, it's involving Patrick Westfall and it's involving trees. I think that was the point, really. Okay, so this is significant because of the F found on the tree in one of the victim's blood, in Libby's blood. Law enforcement had believed that the tree was marked possibly by someone practicing Norse paganism or Odinism. The defense did not get a copy of this exculpatory video. Rather, it had to ask the prosecution for that video. Eventually, that video was turned over to the defense. It is not normal for the defense to continually have to request the prosecution turn over evidence of an exculpatory nature that the prosecution has in its possession. Normally, the prosecution turns over that evidence immediately without any need to request it. Yet another example of the state of Indiana holding on to exculpatory evidence before being forced to turn it over. Conclusion and request. What has happened throughout this case is not normal. Prosecutors not turning over exculpatory evidence to the defense is not normal. Prosecutors holding on to exculpatory evidence until being forced to provide it to the defense by complaints from the defense is not normal. Prosecutors claiming that they can't locate a key exculpatory witness's identity, a witness, mind you, that purportedly altered the way that the case was investigated, is not normal. Later, learning that the prosecutor had knowledge of the witness's identity in spite of an email sent to the defense claiming he may never learn of the witness's identity is not normal. Gull is not normal. Yeah, and McClelland is not normal. Yeah. He should have put that in as well. That would have got him disqualified. The prosecution having no explanation for not providing exculpatory evidence to the defence is not normal. Having no explanation why a report that attempted to explain what key evidence is forever lost and not dated is not normal. Having a seasoned law enforcement officer recant 2 prior sworn statements concerning a key piece of exculpatory evidence that the ISP claims it cannot locate is not normal. Finally, having a prosecutor claim in an email that he provided all the Ricci Davis letters to the defence before trial, when just 14 days later he was forced to admit that what he, McClelland, represented as truth in his email was in fact not true. This is not normal. Yeah, many people in Delphi are not normal. How did they get away with this? Because Judge Gull lets them get away with it. And she's let them get away with it throughout the entire trial, pre-trial. Richard Allen has been the fall guy, he's been the patsy, and Judge Gull has been the willing enforcer. Nor is it normal that one of the letters can't even be located, and that the prosecution has no explanation for the missing Ricci Davis letter. It does not matter whether the contents of those letters can be questioned as unreliable. It is not for the prosecutor to determine. The prosecutor's only determination is to turn that evidence over to the defence. The defence should have had the opportunity to determine the value of that information contained in the letters. It does not matter whether those letters may conflict with other defence theories, as the defence has a constitutional right to possess all exculpatory evidence and then to determine how it should proceed strategically in the defence of their client. A local Carroll County rule also requires turning over said evidence. The fact is that the prosecution had in its possession letters in which a key suspect, Ken Klein, reportedly confessed to the crimes and provide details that only the killer might know. And that information should have been provided to the defence. Because of the prosecution's failure to produce those letters, and because the prosecution has a history and a pattern of not turning over exculpatory evidence, Richard Allen deserves another trial. Richard Allen, through his counsel, therefore seeks a hearing in which the prosecutor is requested to explain why he failed to turn over the Ricci Davis letters, which he misrepresented in his possession of those letters to Defence Counsel in his February 13th, 2025 email, as well as to explain the other examples of failing to turn over exculpatory evidence as recited herein, which shows a pattern of such conduct. The defence seeks such a hearing in order to, 1, use the state of Indiana's answers to these questions in a renewed motion for a new trial based upon newly discovered evidence, and also 2, in order to use the state of Indiana's answers to those questions as a record that can be utilised by the appellant lawyers should this court deny his request for a new trial. Lastly, Allen asked this court to order sanctions against the state of Indiana for violating the Carroll County local rule concerning exculpatory evidence. The sanction the defence is seeking is ordering a new trial. Wow. That is going to be denied without hearing. Denied without hearing. I swear and affirm that the statements contained in this memorandum are true and accurate to the best of my knowledge. Andrew J. Baldwin. That is a Baldwin special. That last paragraph is amazing. I love that. Allen asked the court to order sanctions against the state of Indiana for violating the Carroll County local rule concerning exculpatory evidence. The sanction the defense is seeking is ordering a new trial. Go, Andy. Go, Andy. We should get like t-shirts printed like Team Andy. Team Baldwin. Oh dear. Dear, oh dear, oh dear. Dear, oh dear. Kathy Shank, according to her daughter, was honour bound to Ron Logan, and she cleared Ron Logan in Orion once he died. Also, according to Ricci, Nick is Ron Logan's family friend. Yep. Isn't it interesting that Nick McClellan took office as Carroll County prosecutor in December of 2017, and then in January 2018, less than a month later, Ron Logan was released from prison where he was serving his sentence for parole violation. He violated his parole. He got sent back to prison to serve his sentence. As soon as Nick McClellan took office as Carroll County prosecutor, Ron Logan was released from prison to serve his sentence at home. To serve his sentence at home. So presumably he had a tag on and he could only go to certain places. But he served his sentence at home. There you go. Absolutely, this should have been a special prosecutor. This is what I'm saying all along. He's a member of Libby German's extended family. For that reason alone, let alone the amount of people he knows in Carroll County because he grew up there. He's a member of Libby German's extended family. Nick McClellan's aunt is married to Libby's granddad. Libby's biological granddad, Brad German, is married to Nick McClellan's aunt. That's how close these families are. For that reason alone, this should have been a special prosecution. That's it. Richard Allen isn't part of the family. Absolutely. The people that Nick McClellan wants to protect gets protection. Brother Brad gets protection. Family friend Ron Logan gets protection. Simple as that. Simple as that. Is it up to the defence to make a complaint about Judge Gold to the judicial branch that oversees judges, or do you think she's being watched since they were already alerted to her? No, I don't think she's being watched. I think that if the Supreme Court thought there was any problems with her behaviour, they would have disqualified her. Back when the case was before the justices at the Supreme Court, I don't think they're watching her at all. I think they're... I'm not going to say that they're complicit, but they're going to be more lenient on one of their judges than disqualifying them in a highly public spectacle of a case. But Rick Allen, you know, he wasn't originally from Delphi. He was a quiet guy, liked to have a pint in the pub, liked to have a game of pool, liked to spend time with his family, liked to go on, you know, vacation with Cassie, and, you know, brought up his daughter, worked at CVS, just had a quiet life, just a normal suburban family guy. And he's not part of the family. He doesn't have the special protection that other people who are way more suspect. There's way more evidence against him. Ron Logan, there's more evidence against him. Kegan Kline, despite him being a big fat liar, at least there's some evidence against him. The Odinists are really suspect to me. One of them, Elvis Fields, the wannabe Odinist, confessed on the morning of February 14th, 2017, before the girls were even found. He confessed to his sister before the girls were even found. It was only when his sister saw it on the news that she realised what on earth Elvis was talking about. He was borderline manic. She couldn't understand what he was on about being on a bridge with one of these girls. And Abby was a troublemaker, so he put horns on her. He was there with them. Murdered them. Don't know whether they use the word murdered, but look, even before the girls were found, Elvis Fields confessed to his sister. Ron Logan has confessed. Ron Logan has confessed to things that only the killer would know. Ron Logan, when investigated by the police, his phone was in the vicinity of the bridge at 2:09 p.m. It was in the vicinity of the crime scene at 7:56 p.m. and at 10:16 p.m. What more? What more? What evidence is there against Richard Allen? Oh, there's a psychotic confession that does not make sense, like when you compare it to the state's own evidence that they presented at the trial, and the jury couldn't work that out. They had to get every other possible thing that the offence could use banned from the trial so that the defence didn't have a leg to stand on in reply to some of these ridiculous things. Judge Gull allowed a Google search to be admissible evidence of an expert witness. It's unbelievable. Come on now. The fact that Richard Allen was confirmed by a psychiatric professional, not Waller, to be psychotic during the time he made these confessions should have been all the judge needed to ban those confessions from the trial. They should not have been admissible evidence because Richard Allen was not in his right mind when he said those words. And nothing will convince me that Rick Allen actually said those words that the state say that he said to Monica Waller, when during one of the only times that he was not videoed, during his time at Westvale, he confessed to Monica Waller, and that's what the state used. Doesn't fit any evidence, but that's what the state used, and the jury believed it. Unbelievable. Unbelievable. How much more evidence do they need for reasonable doubt? I don't know. But this is going to be denied without hearing. It'll be interesting to see whether Nick McClellan replies before Judge Gull denies it without hearing, or what. Or whether she'll just say, no sanction. Nick's my beautiful blue-eyed boy. I'm going to protect him at all costs, even though I should be sanctioned myself for this absolute ruin that she's made in this case. But no. All right, guys, I'm going to go out of here. Cassie keeps farting. I think she needs a poo. So I'm going to go and open the door for her. She probably also wants a walk. But there you go. But I've got an hour before the Karen Reid hearing. Karen Reid hearing starts in just over an hour, 11 a.m. Eastern, which is 4 p.m. my time. So that's a motion to dismiss. That's going to be denied. I would guarantee you that. But anyway, thank you for joining me. Thanks as always to the mods. Thank you to those that donated earlier on in the live stream. We got donations from Sherry. Sherry also, well, 2 donations from Sherry and 5 gifted memberships. Donation from Krista. And what's that it? Was that it? And yeah, that's it. We got Daughter of Scotland member for 43 months, Angie Baby for 19 months, Journey Takes a Trip 21 months, and Christina 29 months. All right. Enjoy the rest of your day. And I'll see you over there in Karen Reid if you're following that craziness as well. All right. Bye, guys.